there's some frequently asked questions regarding bills with what's called the public right of access disclaimer. So if you've ever read a bill that contains a section at the end, what we call a plus section, it would be something along these lines. The legislature finds and declares that Section 1 of this act, which amends section of whatever code, imposes a limitation on the public's right of access to the meetings of public bodies or the writings of public officials and agencies within the meaning of Section 3 of Article 1 of the California Constitution. Pursuant to that constitutional provision, the legislature makes the following findings to demonstrate the interest protected by this limitation and the need for protecting that interest. Sensitive information of California taxpayers should be adequately protected from disclosure during the process of the assessment and collection of taxes to protect privacy and increase compliance. Now, why is this language required to appear in a bill section? The California Constitution in Article 1, dealing with the Declaration of Rights, in Section 3, provides in part that the people have the right to access information concerning the conduct of the people's business, and therefore the meetings of public bodies and writings of public officials and agencies shall be open to public scrutiny. Now, how is this constitutional provision applied by the courts in this state? Section 3 specifies that a statute, a court rule, or any other authority, including those in effect on the effective date of this subdivision, are required to be broadly construed if it furthers the people's right of access and narrowly construed if it limits the public's right of access. What happens if there's a future statute or court rule that is adopted? Section 3 specifies that a statute, court rule, or other authority adopted after the effective date of this subdivision that limits the right of access is required to be adopted with findings demonstrating the interest protected by the limitation and the need for protecting that interest. What does the state constitution require for limits on public access? It says that these provisions of Section 3 require a statute that limits the right of access of the public to be adopted with legislative findings that make clear that the interest that is being protected by limiting public access, and then justifying the need for protecting the public's interest. How does the California Constitution affect existing laws on public access? Section 3 also includes a provision that states that nothing in this provision of law repeals or nullifies, expressly or by implication, any constitutional or statutory exception to the right of access to public records or meetings of public bodies that is in effect on the effective date of this subdivision, including but not limited to any statute protecting the confidentiality of law enforcement and prosecution of records. And finally, is there a requirement for local government to meet? Section 3 requires each local agency to comply with the California Public Records Act, as well as the Ralph M. Brown Open Meetings Act.